This is KBCI.blogspot.com, George Foster Rhymes on YouTube. I'm in Quitman in the city of Quitman in the county of Brooks in the state of Georgia. We just left a meeting wherein with the Honorable Civil Rights legend Tyrone Brooks, and we just interviewed people about their experiences with the G.B.R. and the voter registration here in Brooks County, along with the Quitman 10. And while we was getting ready to exit, we met a beautiful brother here. What's your name, my beautiful brother?
James C. Brown III.
Okay. And you were telling my beautiful brother Tyrone Brooks, what were you telling him about your experiences?
The G.B.R., they came to my house, and I allowed them to enter. They started asking me questions. And so they had a copy of my voter absentee ballot. And they asked me, was that my signature on the ballot? And I said, yes. So I was wondering where they got the ballot from, but I never asked them that question. So then they asked me other questions. They asked me, did I fill out the ballot? And I said, yes. And I sealed the ballot, and I put it in the other envelope and sealed it too. And I asked them, why were they there at my house? Because there was no voter fraud going on at my house, because I was the one that filled out the ballot. And then they asked me who mailed it, and I didn't answer that question. And then they told me that I would be getting subpoenaed to court. I told them that's fine. I'm represented by a law firm out of Atlanta. And then I asked them what their names were and their badge numbers. And the other one, the first one told me his name was Steve Turner, and the other's name was Mark Crow. So
I'm familiar with Turner.
And I asked him, I said, how do you spell your name? So he said M-A-R-K. And his last name sounded weird to me, so I asked him how he spelled his last name. He said P-R-O. And I don't know why he did that, because one of the other questions he asked me was I literate? Could I read? And I told him yes.
Oh my God.
And so I was, you know, things got I was a little upset, but I kept my composure. And I told him at one time that I don't know why they asked me these other questions, because they have nothing to do with the investigation. And there was no voter fraud going to my house, so they needed to go and find someone else to talk to. And that was pretty much the end of the conversation.
Okay, I have a question for you. What were your profession? What kind of job have you held since you left high school?
I went in the Navy right after graduation. And I got out of the Navy in '92, but I went into the reserves, and then in '94 I enlisted back into the regular Army, active duty, and I retired from the Army on March the 1st, 2010.
Okay, go ahead.
And I'm currently a bail bondsman. I've never bailed anyone out yet, and I'm a city councilor.
Yes.
I was just duly elected in November.
That's what I wanted. And I also want one other thing. I want to know, because I just read, and Mr. Brooks, I got this in your package there, wherein there's a federal judge that made racist comments about our president. And so out of all the 44 presidents, I think that the last one, President Barack Obama, received more negativity than any president in the history of this country. So I'm bringing that in because of you and what you've done. You serve your country, am I correct?
Yes.
But yet you feel, I mean, something with the G.B.R. and your voting, you own in foreign countries. By you being in the military, you could have gone to a foreign nation to die, right?
Yes.
On the battle line.
Yes.
Now, aren't you a disabled veteran? I think you, tell me about that, your disability. That's what I want on here.
Yes, I'm a disabled veteran, 80% disabled. Currently working on my 100%, and I've served 2 tours in Iraq.
In Iraq?
In Iraq.
Have mercy. And then for you to come here and to receive questions about voting and voting rights, that reminds me, if not you, of Jim Crow, back in the days when we had to count how many bubbles in a bottle of water, all these other crazy questions. So you are one person who know about the alleged G.B.R. intimidation, am I correct?
Yes.
And
I consider that a travesty of justice, and all travesties of justice should be answered up for. And once they look into this, then the mistake can be corrected, and the Quitman 10 can be exonerated.
Okay, I want to know your personal opinion. We're going to close this out now. That takes care of that. And I thank you for your statement. But what do you think in your own words? Give me, I didn't hear this today. I want to hear one person to tell me, I'm going to step off and I want you to talk from your heart. How do you feel about the Quitman 10 and what happened to them?
Well, I've known most of the Quitman 10 most of my life. I grew up down the street from a couple of them. And they are just people. They are upright people in the community. I've never heard anything bad about any of them. And I just think that this town is still with the 60s mentality, if not before. There's no representation. The city is mostly black, but all of our leadership is white. The mayor is white. The chairman of the board for the county commissioner is white. The sheriff's white. The police chief is white. And now all of a sudden that we have blacks in charge, that's a problem. And I also wonder if they said there was a problem, there was a spike in the ballots, did they check all of the ballots, not just the ballots that were for the Quitman 10? Did they check the ballots that were voted for on the other side? Or it was a one-sided investigation? So I truly believe that the Quitman 10 has been dealt a bad hand, and I'll be glad when this is all over and they are put back into their positions, because I believe what the governor did was unconstitutional.
State your name and position that you hold and your address one more time for us.
I am James C. Brown III. I'm a city councilman in District 1, Post 2. My address is 716 East Lafayette Street, Quitman, Georgia, 31643.
Do you remember the date that you were visited by the G.B.R. agents?
I do not remember the date.
You remember the month?
I cannot even remember.
What year was it?
I don't. I believe I wrote all that down on an envelope that I have, because after they left, I called the Department of Justice and I reported their names, and I think I had their badge numbers.
Was it before the Quitman 10 were arrested or after?
I believe it was before they were arrested.
Before they were arrested,
yes.
Okay. Thank you very much.
This is kvci.blogspot.com, George Boston Rhymes, YouTube, Boston G.B.R. We do what we do because we want you informed. Once again, thank you, my beautiful councilman. May God bless you. Thank you, Brother Brooks.
How can you do me wrong when I'm doing you right? Baby, when I'm doing you right. Yeah, I bought you a car, house, and a diamond ring, and you're acting like I haven't done a thing. I wanna know how can you do me wrong when I'm doing you right? Tell me, baby, I wanna know how. Oh, I wanna know how can you do me wrong? Oh, baby, when I'm doing you right. Oh, yeah, when I'm doing you right. I work the full-time job, part-time job at night. Oh, yeah. Even worked on the weekends, baby, to help make ends meet. Oh, yeah. I thought I was doing you right. Baby, I thought I was doing you right.
The bottom of it, that we don't have to come back and revisit. But if we pass it off as a systemic issue that is a fallacy of dramatic instance, we'll see it again and again and again. I've showed you 3 cases of it. 3 cases of it. It goes back to 2010. And so at what point do we finally decide to look at this? Because as we go forth, if we don't do anything today, then it's our fault.
Thank you for being here. You made your position very clear, and the board appreciates that. All right. Do we have any recommendations from the board? Motion?
I'd make a motion to dismiss this case.
Got a motion to dismiss by Mr. Worthing, second by Ms. Sullivan. Any other discussion with the board? Hearing none, all in favor signify by saying aye. Aye. All opposed, same sign. We agree to dismiss. Thank y'all for being here today. All right, Mr. Harvey. Then while we've got your document for you.
It's been dismissed, it doesn't have a relevance, right?
Mr. Harvey.
Yes, sir.
I'm showing that we have moved past our consent cases and we're now to our letter cases.
That's correct.
All right, let me explain what we're doing. This is the first time that we have done this. As you all know, several years ago, we decided having the consent calendar to try to speed the meetings up and get people on the road quicker, or have them not have to come to this meeting at all by voting certain cases in block. Mr. Harvey has recommended to the board that we would start doing the same with our letter cases. There are certain cases that we get that are more technical in nature, not as serious potential violations, and the recommendation is for a simple letter of instruction. What we've decided to do is to go through the same process with these cases as we have with our consent cases. We believe this will help the board clear our caseload quicker, be more efficient, and hopefully be a little easier on you all that have to travel to the meetings. So that being said, we'll go through the same process for the letter cases. If there anyone is here that does want to hear this case, either in the audience or with the board, we'll pull them out and hear them, but if not, we're going to vote in block to recommend a letter of instruction in all of these cases. And they're case number 2013, number 36 is a Pierce County case. 2013, number 27 is a Burke County ballot case. Case number 2012, number 102 is a Marion County case. And then we added SEB case 2014, number 23, which was on the consent calendar that we moved down, which was the Paulding County case.
Yes, sir.
Is there anyone that would want us to pull one of these cases out and discuss it, where you can comment on it? Yes, sir.
Marion County.
Okay. We'll pull the Marion County case off. Anybody else? Okay, any board members want to pull a case?
Mr. Secretary, just for the record, Pierce County and Paulding County submitted responses to the State Election Board regarding these cases. Paulding County sent an email acknowledging their error and saying they would accept the letter of instruction, and largely the same with Pierce County. So for the record, I would submit that to the State Election Board.
Okay. All right. Is there any board member who pull a case out? Y'all ready to? All right, hearing none, we are ready to take a motion to do letters of instruction on SEB case number 2013, number 36, number 27, and 2014, number 23.
Move that the board issue a letter of instruction on those cases.
All right, Ms. Sullivan moved. Do you have a second?
Second.
Mr. Simpson seconds. Any other discussion? Hearing none. All in favor signify by saying aye. Aye. All opposed, same sign. That motion carries. And then, Mr. Harvey, I'll call on you for 2012, number 102, the Marion County case.
Yes, sir. This case involved about 14 different allegations of problems. There were allegations that, I'll try to take them and summarize them, that people were seen, that a poll officer was seen carrying absentee ballots, that a commissioner was seen in the room where tabulation was taking place. The tabulation wasn't done properly. There was a complaint about not responding to open records requests, which of course the board doesn't have jurisdiction over. There was an allegation that somebody didn't receive a candidate on a ballot. Somebody had problems with the voting machines. somebody complained that they didn't think the vote was right because they had gotten 800 phone calls from people who saying they voted for him, and the person only got 555 votes. The allegations that the vote printouts weren't properly posted, and that the elections office failed to post notice of logic and accuracy testing. So after doing an investigation of all those allegations, we found that in one case, the second allegation regarding the county commissioner being in the election office area during tabulation, he was in the office area. There's no indication that he was actually touching any ballots or participating in the tabulation, so I'm not sure that even constitutes a violation. The potential violation that we did identify was 21-2483 in, you know, if the entering into the tabulation area without being deputized is a violation. I'm not sure that would be sustained, but that was the only violation that we found in all the allegations, that he was in the tabulation area. He was not deputized. There's no indication that he was performing duties as an election official.
All right, any questions for Mr. Harvey? Anyone else wishing to speak? Good morning.
Morning, sir. My name is Anthony Dixon. I'm the election supervisor in Marion County. My address is 98 Village Lane, Mark, UK, Georgia, 31058. A statement of interest from the Marion County Board of Election and Registration to our state election board. In reference to code 0CGA21-2-48B. The first paragraph reads, all proceedings at the tabulation center and precinct shall be open to the view of the public. Mr. Larry Ogun, the commissioner, along with others, has the right to view the tabulated proceedings, but not participate in the tabulation proceedings. Mr. Ogun was merely coming through the main interest of the election office after a full day on the job to make inquiry regarding the completion of the voting tabulation and when those results will be announced. It is our understanding that after the inquiry, that Mr. Ogun proceeded through the area of the office which is utilized for daily operation of the Board of Election and Registration to adjoining waiting room where the tabulation results would be announced. Those present at the tabulation area during the scanning of the ballots and the proceedings was the members of the Board of Election and Registration, which consist of a board member and which consists of a board chair, 2 board members, the chief deputy register, the ballot review panel, which consists of Democrat and Republican, the E&S technical service representative, and of course the election supervisor. I'd like to reiterate, the scanning of the ballots is open to the view of the public, and at no time did Mr. Ogun participate in the tabulation proceeding. There was therefore no need for any board member or elected supervisor to deputize Mr. Larry Ogun.
So, well, thank you for being here, Mr. Dixon. So in your opinion, there was no violation and there's no need for a letter?
Absolutely, sir.
Okay. Any other questions for Mr. Dixon? All right, thank you for your answer. Mr. Harvey, do you have anything you want to add?
I think I tend to agree with Mr. Dixon. I think that there's, I don't see a specific violation. Recommend this case be dismissed.
All right, anyone else wishing to speak on this matter? I'm ready for a motion.
Move to dismiss this case.
Second.
All right, Mr. Simpson moves to dismiss. Mr. Holden, second. Any other discussion? Hearing none. All in favor signify by saying aye. Aye. All opposed, same sign. That motion carries, and we have dismissed that case. Thank you again, Mr. Dixon, for being here. All right, Mr. Harvey, we're now going to move on to the new cases. Is that correct?
That's correct, sir.
All right, for those of you that are here today, one of the other things that we've been trying to do to help the folks that take the time to come to our meetings is to go down this list of cases, and if there are people who haven't showed up, we'll move them to the bottom of the calendar so we can get to the folks that are here quicker. So if you would just raise your hand or say here when I call these cases, we'll to move through these real quick. You don't have to say anything about it. Just say that you're here or raise your hand, and we'll try to put some of these at the back if everybody showed up. 2012, number 31, Telfair.
Here.
Okay. Fulton County Sobey case.
Present.
Okay. Brooks County absentee ballot case.
Here.
Okay. Floyd County voter districting. Cook County.
Here.
We got a Long County case. Okay. City of Ludowici. City of Ludowici. Okay. All right. Jefferson County. Okay. Montgomery County. Dooley County. Here. Stewart County.
Here.
The 2012 number 182, which is absentee ballot via FedEx case. Another Long County case. 2013 number 6, Long County. City of Valdosta.
Here, sir.
Chris County. Felon case, Chris County. City of Osceola case. City of Lumpkin, which is Stewart County. Sumter County. City of Woodland.
Here.
The Tiff / Colquitt County, City of Omega. City of Brunswick, Glenn County. The Toombs County qualifying case. Okay. Sumter County residency case. Okay. Long County qualifying BOE case. Ma'am, are you here for City of Lewis? And then the last one was Camden County.
Here.
All right. Thank you all very much for that. All right, Mr. Harvey, the first one is 2012 number 31, which is Telfair County number 38, my binder.
Yes, sir. This case had three major areas of complaints. The first complaint regarded allegations of absentee ballot mishandling and fraud. The second centered around problems at the Lumber City precinct on election day. And the third was something that our investigators discovered during the process of the investigation, and it had to do with administrative errors and failures with election documentation. Regarding allegations that absentee ballots were being improperly handled, processed, and illegally assisted, we had cross complaints. We had several different sides alleging that absentee ballots were being improperly handled. We were unable to determine that there was any large conspiracy, that there was any type of organization that was involved. We interviewed approximately 50 individuals regarding absentee ballots. We did come across several cases where individuals either illegally assisted people with absentee ballots and or illegally failed to document assistance, and several cases where people illegally possessed absentee ballots once they had been voted. We had gotten reports from people that absentee ballots had showed up in bundles at the post office. However, there was no indication of who may have handled those ballots and collected those ballots. So as far as the general allegation that absentee ballots were being improperly handled, while there's some indication that there may have been something going on, with all the investigation we did, we were unable to determine if it was a concerted effort. We ended up interviewing 33 absentee ballot electors in terms of trying to see if there was any connection, and what we found was there were 13 instances of those 33 of illegal activity. we found out that the following people illegally possessed absentee ballots, and those people were Beulah Dollar, Linda Clemens, Patsy Vaughn, and Alice Strong. We found that several people either illegally assisted or failed to sign as assisting when completing an absentee ballot, and those were Inez Carnes, Linda Clemens, Beulah Dollar, Alice Strong, and Martha Williams. As far as allegations with the Lumber City Precinct, our office received several complaints from people about the Lumber City Precinct. Interestingly, we didn't, as far as I can tell, we didn't receive many complaints from individuals who actually experienced the problems, but we got a lot of sort of general complaints about what happened in Lumber City Precinct. And most of them involved people who had requested absentee ballots who were attempting to vote on Election Day. And we interviewed 4 out of the 5 poll workers, and what we found was that when people had either requested an absentee ballot and had not returned it, they came into the polls and wanted to vote on Election Day. They, of course, were told they had an absentee ballot outstanding and that they had to cancel that. And the people at the poll office reported that they had difficulty getting in touch with the registrar's office to verify that somebody still had an outstanding absentee ballot. So that caused some delay, and I think that contributed to the report that people were not being allowed to vote, because of course if you show up to vote at the polls with an outstanding absentee ballot, you should be stopped from voting until they can clarify whether or not your ballot is still outstanding, and you cancel it. But as the board knows, there is certainly a procedure for doing that. All the voters were allowed to vote provisional ballots if necessary. There were reports that people came in wearing shirts that had candidates' name on them. In every case, those people were intercepted and were told to turn their shirt inside out or go out or fix it. And in every case, we followed up on the people complied with that. At one point, there were some contraband flyers found near the front of the polling place at Lumber City. As soon as that was identified by the election officials, that was confiscated and destroyed. There's no indication as to who put that campaign literature there, but that would certainly be in violation of the law. And again, the complaints, we didn't receive a lot of specific complaints from specific individuals. As far as the administrative errors, when we started to examine these absentee ballots to attempt to detect any fraud, we also found there were problems with voter certificates, of course, which people fill out when they vote in person. And we found that there were 2 voter certificates that were accepted without a voter's signature, 13 that were accepted without the voter's date of birth, 14 accepted without the poll worker's signature, 33 accepted that indicated there was some assistance but didn't provide a reason for assistance. There were 49 certificates that were accepted without the elector's address. There were 51 certificates that were accepted with no indication that the voter's ID was checked or what form was presented. There was one case where a voter named Fred Hammonds III went in to vote. He was not registered to vote. However, when he filled out his application, the poll worker pulled up his grandfather, who was registered to vote, who was Fred Hammonds I, and they allowed Mr. Hammonds III to vote in the place of his grandfather when he wasn't registered to vote. I think it was an error on the poll worker. He or she saw the same name and allowed Mr. Hammonds to vote when he was not registered. We do have in the citations, we have a Michael Allen cited for failing to correct a voter's ballot. In this case, there was a voter who went to vote, and she contacted the poll worker and said, "I'm not sure if I have the right ballot because I think I might have this candidate and I should have that candidate." Michael Allen told her, you may not know what district you're in. You may have the right ballot. You may not. She went and voted. Initially, we had him cited for a violation of not correcting her ballot. Upon further review and going through the case, I don't know that there's evidence to sustain that. He did not tell her, you have to vote that ballot. I think the voter equivocated as to whether or not she had the right ballot or not. So I don't think there's a charge to sustain on Michael Allen. I would recommend that specific violation be dismissed. To bring it all to a close, for the respondents, I would recommend that the Telfair County Board of Registrars, the election superintendent, Rebecca Widener, Betsy Johnson, and Linda Cartwright all be bound over to the AG's office on the citations that are listed in the report. I recommend that Fred Hammonds III, Alice Strong, Beulah Dollar, Patsy Vaughn, Linda Clemens also be bound over to AG's office on their listed violations. And then for Inez Carnes and Martha Williams, these are women who assisted their disabled husbands in voting their absentee ballot. They did not sign as assisting. There's no indication that there was anything nefarious or malicious in doing that, and I recommend that they receive letters of instruction reminding them about the proper necessity to document assistance with an absentee ballot.
All right, any questions for Mr. Harvey? Mr. Worthing?
I have a question, Mr. Harvey. The 162 counts about improperly completed voter certificates. Do those relate to more than one precinct?
Yes, those were more than one. That was the total that we looked at.
Anything else, Mr. Harvey?
No, sir.
Anyone else wishing to speak? Yes, ma'am.
Good morning,
Good morning.
Mr. Secretary of Election Board members. My name is Tony Sawyer. I am the county attorney for Delaware County. My address is 311 West Central Avenue, Fitzgerald, Georgia, 31750. And I'm here to speak on behalf of Delaware County Board of Elections, the current Delaware County election superintendent, as well as Ms. Cartwright, the former Delaware County election superintendent, which is also probate judge. Ms. Johnson is actually here today, and she's represented by her own personal attorney. I did provide a response to Mr. Harvey, and we communicated by email. And if I may, I'd like to address Ms. Linda Cartwright first. The allegation that she allowed Mr. Hankins to vote, to cast his ballot. Ms. Cartwright was not the individual that actually was up front that assisted Mr. Hankins. There was another individual, another poll worker. And what occurred is that there were actually 3 individuals named Fred Hankins that were registered to vote for that particular precinct that lived in the same household. There was a Fred Hankins Sr., a Fred Hankins Jr., and a Fred Hankins III. When this individual came in to vote, he gave the name Fred Hankins and provided his ID. The gentleman that assisted him did in fact look at the ID, but he did not check the date. We do not in any way deny that that occurred. And from that point, Fred Hammond III was, for whatever reason, allowed to vote under Fred Hammond Sr., and we do apologize for that. So we just wanted to make it clear that it was not Ms. Cartwright, so we would ask that the charge against her be dismissed. She was poll manager, but she was not aware of what was going on. If I move forward with, let me just move forward with the Delaware County Board of Registrars with regard to the issues with the absentee ballot applications, as well as issues with absentee ballots. The only thing that we can say is that we sincerely apologize that this occurred. At the time of this July 2012 primary, we had a completely new staff. The chief registrar had just been hired in December. She had not received any type of training other than 2-week training in-house with the prior registrar. She had not had the opportunity to attend any type of B-RAG training or any other type of training that was offered. So at that time, staff just really honestly did not know. What we can say now is, as far as training, Chief Registrar has been trained with B-RAG. She's been trained in 2012, 2013, 2014. She's coming up for the 2015 training. She does the ElectioNet training. She now does the mandatory continuing education for the registrars, which I think is 12 hours. Her new assistant is also signed up to attend 2 sessions of B-RAG training this year. Now when there's an issue with the application ballot, we send out letters informing the voter that there's an issue with the ballot application, absentee ballot application, explaining them what the issue is. We send them a new absentee ballot and ask them to complete it. If we get a ballot and there's problems with the ballot, we send them a letter explaining why the ballot was rejected. and then we will tell them their options that either, you know, if time permits, they can come and vote in-house absentee or vote at the polls. We have worked on that, and it's my understanding that I was not the county attorney in 2012. Mr. Marchant, who's representing Ms. Johnson, was actually the county attorney at that time. But since I've been a appointed county attorney, I don't think there's been any other complaints as far as registrar's office that I'm aware of. The issue with the election superintendent's office, which is also the probate judge, again, all we can say is that, you know, these errors occurred and we apologize. We have new poll workers. These poll workers now are being trained 4 to 5 hours per each election. And in addition to that, the poll workers are individually trained on their individual duties at the poll. So if somebody is to be up front and working on the voter certificates, they are shown individually, this needs to be completed, this needs to be completed. Of course, they have to complete the electioneer training. So we are working on making sure that what occurred does not occur again. And again, as far as I'm aware, there have been no further complaints with regard to the elections superintendent's office for any elections after the 2012 primary. All right.
Thank you for being here, Ms. Sawyer. Any questions for Counselor? Okay, thank you.
Secretary, just for the record, I'll submit what Ms. Sawyer spent to me for the board's consideration. Also, I have an email from Michael Allen, who's the person that I suggested be dismissed. Explain his position.
Thank you.
Thank you. All right.
Mr. Chairman, my name is Joseph Marchant. My address is 303 Main Street, P.O. Box 4218 is my mailing, Easton, Georgia 31023. I'm here only on behalf of Miss Betty Johnson, who was the probate judge and election superintendent at the time of this election. She has since retired, and just a little background on Ms. Johnson. She has served our county as a public servant for over 30 years. She served 2 terms as clerk of Superior Court. Our county has the 2-term tenure act, which is something that's kind of rare in Georgia. I don't think there's very many that have that. So she, if it had not been for that, she would have continued probably in the clerk's office. But at some point, she made a transition into the probate court. She actually served as a clerk there in the probate court for 8 years, but during that time period, she didn't really handle elections. Wasn't really involved in that. When the probate judge, who's actually now the current probate judge, previously served 2 terms, and Ms. Johnson ran for office and was elected. And this was also one of the first elections that she held, certainly a large-scale election. Essentially, we don't disagree with anything that Mr. Harvey said with regards to the 2 issues that affect Ms. Johnson. The only 2 issues that really affect Ms. Johnson's office is the discrepancies in the voter certificate cards and some information that was missing from those. We went through and looked at those ourselves, and we would agree that it was that type of information, various things that was missing from those cards. Obviously, the poll workers looked over that. She's not going to actually examine 3,500 cards, but it is her responsibility as the election superintendent. I think as has been previously discussed, it appears that those things are being corrected and have been corrected through the current election officials. The other issue is this issue with Mr. Haynes. This is an issue that could have happened anywhere. Had something very similar almost happened in my office this week. There were 3 Mr. Haymanses. The first, the older 2 died and left the grandson. The grandson was actually inherited the house of the grandfather. And so he moves in his house, so he's getting his mail there. And he also gets a voter registration card. It's his grandfather's card apparently, but he believes that it's his. And that's why he went to vote. And a matter of a 3rd versus senior or not checking the date of birth. There's no criminal intent with any of this stuff. mistake occurred. Ms. Johnson has since retired. She has no plans to return to public office that I know of. We would ask that the case be resolved with a letter of instruction and not be referred to the AG's office as it relates to Ms. Johnson only. Thank you.
Okay. Any questions, Mr. Marks? Thank you. Anyone else? Yes, ma'am.
I am $0, and my address is 58 East Gwinnett Street, Post Office Box 75, Lake Ridge, Georgia 31055. And I have been cited for having possession of absentee ballot. The persons that were mentioned were Yvonne Stustier, who is blind, Randolph Freeman, from a stroke and has paralysis in his hand, Brady Hamilton is blind, and Johnny Fuller. Okay, I assisted these persons. I also signed these absentee ballots that I assisted them. Yvonne Stustier always make an attempt to write her name. I have her finger, a piece of paper, and put it on the line. And then she signed and up and down. But I signed my name that I assisted her, and I wrote on there the reason that because of blindness. And so when the investigator came, she said that they had her to write her name. She said she wrote it and she write it whenever she was doing her absentee ballot. I assisted her because she could not see how to mark the candidates. And I signed my name that I assisted her, and each time. On Brady Hamilton, the same thing transpired. He said that he could sign his name, but he could not make the choice of the candidates because of blindness. He signed his name, but I signed my name that I assisted him. And then on Randolph Freeman, this is something like a relative, because my son has been with his sister for 37 years. He had a stroke, and I'm almost like his caretaker. I go to visit him several times a week. He has someone has to place him in the bed at night and help him in the morning. I take meals to him, and then on Sunday, along with 12 other people, I pick him and take to him. But he has paralysis in his hand, and he cannot write, he cannot even understand his handwriting. When I registered him to vote, I signed that I registered him because he couldn't understand his handwriting. So I filled in his candidate. He told me who he wanted to vote for. I filled in his candidate. Then I assigned my name that I assisted him. He moved from one apartment to another. I had to do a registration form because to change the address. I signed my name that I assisted him with that because he had a stroke and he could not write. On Johnny Fuller, he lived next door to Arthur Randolph. And Johnny Fuller, he asked me to watch him to see if he was filling the back of his absentee ballot out correctly. He said he had filled out one time before and they threw it out, said it wasn't completed. I did not put my hand on his ballot. The other three, I had to put my hand on that because I had to do the ballots for him. But for Johnny Fuller, he filled it out himself. I watched him while he signed it. And all of these persons, I left the ballots with them once they were completed. So Yvonne Stustier, I think her daughter came in one or two times, but she told me to check on her mother because she was moving away and she could not do her own ballot. And she wished that I would assist her mother. So I left the ballot in their possession, and whoever mailed them, I do not know. Well, I think Arthur said his sister that with my son put his in the mail, and Johnny Fuller, so I had to have them in my possession, those three, because I had to assist those persons. But with Johnny Fuller, I did not touch his ballot. I just observed why he was doing it to make sure he filled it in correctly. And I just pray and trust that you will take under consideration somebody that's totally disabled. Thanks.
Okay, any questions for Mr. Dollar? Okay, thank you, ma'am.
Good morning.
Good morning.
My name is Alice Strong. My address is P.O. Box 324, Lumber City, Georgia, 31549. And I have been cited for, says Ms. Dolores Wright said I took her ballot and she did not require any help. But she did require help, and I have a letter from her son stating that she required help because she had had a stroke. And also, she was housebound. She's an avid voter, but she couldn't get to the poll because she has a motor wheelchair, and it was torn up at the time. And I was asked to go and help her vote. But the only thing I did, she did her own marking on her ballot. But I signed the oath that I assisted her and filled out the back of the oath with her information. And I have this letter from her son.
We have a motion to accept the letter.
So moved. Second.
I've got a motion to second. All in favor, signify by saying aye. Aye. All opposed, same sign. That motion carries. And you'll just hand that to Mr. Carter.
Thank you, ma'am.
Just let us see that letter. All right, Ms. Strong, do you have anything else you'd like to add?
With no sir, because that was the only one, I did not receive a letter from the election board, but I saw someone else's letter, and I saw my name on there, so I decided to come and to let you know what
So
happened.
you're saying that you did not receive notice of this hearing?
No, sir, I did not.
Any questions for Ms. Strong? Okay, thank you.
And, but also if I may, it's in 2012, this election was, the investigator, Ms. Pam Jones, came by my house one day, and, but I wasn't at home. My girlfriend told her I was at work, but she never contacted me, and she also sent me a letter, and asked me to call her, and I called her several times, but I never got her, and I left messages on her voice. She never contacted me.
Okay.
Thank you.
All right, anyone else?
My name is Chris Stevens. My address, 16 Mimosa Lane, McCray, Georgia, 31055. And I serve as the sheriff of Kemp County. Mr. Secretary, I have a folder that has the letters that you just got a copy of, along with some other sworn affidavits. What you have is a sworn affidavit. With your permission, I'll approach and give the board.
We have a motion to accept the documents from the sheriff.
So moved.
Got a motion to second. All in favor signify by saying aye. Aye. All opposed, same sign. That motion.
appreciate the opportunity to come before this honorable board. I don't represent any particular person here, but after I looked into the facts involving the investigation of this case, I felt it my duty to come and speak to the board. I don't represent a certain individual, but I do represent law and order in my county and executing it fairly on the citizens of my county. Due to the time constraints, I had written a letter to the board, but with such little notice, we didn't get it off. So with your permission, I'd like to go over my letter and just point out some facts in case you have some exhibits attached to your folders. I hope you'll follow along and stop me at any point that I can answer a question. I will say also that the Secretary of State's office, the Investigations Division, has some of the most competent investigators in the state of Georgia. I know this because I was one of them at one time. And I know these investigators, and I work with these investigators, and they're very competent. Unfortunately, the investigator that got this case left a lot of questions unanswered. And in my opinion, this investigation was sloppily done. And I'll point out some of those instances in my letter. It is my understanding that several citizens of Delaware County have matters pending before this body. I would like to take this opportunity to address the board concerning my firsthand knowledge of the fine ethics and good character of many of the individuals named in this report, as well as the obvious investigative deficiencies evidenced throughout this case. Firstly, the complaint originated from an individual well known in my office. As a matter of fact, your complainant, John Dawson, is currently being investigated by the G.B.R. for recklessly and repeatedly pointing a pistol to the head of a local senior citizen while threatening the gentleman's life, only because he agreed with Dawson's outlandish and slanderous rants. Closest family circle. Sworn affidavits reveal a sloppy or non-existent investigation aimed only at smearing my family. See attachment number 1, pages 4, 5, 6, and 7, which are sworn affidavits that counter the allegations made against these individuals. I've been a criminal investigator for well over 20 years. I've investigated every crime from shoplifting as a local agency police detective, election fraud as a member of the Secretary of State's Investigative Division, to war crimes as a criminal investigator working overseas for the United Nations. In every case I've ever investigated, all witnesses and all of those accused were interviewed whenever possible. An investigator should never submit to a prosecutor, or in this case, to this board, an investigative report that reflects solely the uncorroborated allegations of the initial complainant. This is not the former Soviet Union, and this is not Saudi Arabia. The agent assigned to this case had 3 years to interview all the parties related to this case. I was told the agent claimed she couldn't find them. I was told the agent insinuated that many of the individuals mentioned in her report avoided her attempt to interview them. This is simply not the case. These people are honest and forthright in all of their affairs. They are definitely not the felons this investigator has accused them of being. After casually investigating this case for 3 long years, the respondents were notified they were being accused of committing various felonies by Chief Investigator Chris Harvey, and their case will be brought before the board in 30 days. I, as Sheriff of Delaware County, was contacted by several of these little old ladies and gentlemen named in the report. Many of these individuals are some of the dearest and sweetest elders of our community, hard-working, honest, tax-paying citizens who came up through the Great Depression and fought in our wars. Some are still involved in serving their communities in some way. They are proud Georgians who up until this time believed in our system. They believed in our election process. One 92-year-old widower, a World War II veteran, often boasted proudly to his family and friends that he has voted in every election since he was 18 years old. This same gentleman told me that he will never vote again because of this ridiculous accusation against his 65-year-old daughter, a retired school teacher, widow, and loving grandmother who has never had even the slightest encounter with law enforcement. Another, Mr. Henry Carnes, a 75-year-old respondent who is also a pillar of our community, stated in his sworn affidavit, "I doubt I will ever vote again based on how this investigation has been handled. It's just not worth the hassle." You can see his statement on attachment 1, page 2. trained career investigator, and at the request of some of the respondents, I read through the investigative findings regarding this case. I quickly realized that there was absolutely no evidence of criminal intent or fraudulent acts, but what appeared to be only minor errors in filling out the absentee ballot envelopes. I also felt compassion for these senior citizens because most are not physically or financially able to defend themselves before this board. I personally hired a private investigations firm to locate and interview the witnesses in this case and to obtain sworn affidavits from them. I merely provided the investigative firm the names of the respondents and witnesses and a copy of the complaint. Promptly, in the course of 2 afternoons, these witnesses and respondents were interviewed and sworn affidavits were obtained. The private investigation revealed that the first time many of the respondents were notified of these accusations was when they received notice from Chief Chris Harvey less than 30 days before the hearings. It also revealed that at least some of the respondents repeatedly reached out to the investigating agent after her card was left on their door and left messages but never being contacted back. At least one lady, Mrs. Carnes, a 71-year-old lady, see attachment 1, page 3, reported that she recently contacted Chris Harvey directly. The respondents and witnesses in this case obviously did not elude investigators, but instead attempted to reach out to them. There are several factors responsible for any errors that may have been detected by the state's investigator in this case. However, even the slightest insinuation of criminal intent and or fraud is grossly unjustified and not supported by the facts. At best, many of the scenarios described in the investigator's report can be attributed to common errors and innocent mistakes. Mistakes such as poll worker did not check the box that an elector's driver's license was inspected 33 times countywide. Out of 35 ballots cast, that's not bad. Elector did not fill in the blank for the street address, 18 counts countywide. Elector signed their name in the wrong line, 1 count. Poll worker did not check the box that elector was physically disabled, 10 counts. These and similar violations go on and on to equal some 162 counts. I think this board would agree that the fine print regarding the oaths on the absentee ballot is very tiny at 1/16 of an inch. You can see an attached sign. The oath of person assisting elector states that only if the person assisted in marking such elector's absentee ballot are they required to sign the oath. Obviously, the investigator assigned to this case also had trouble reading the fine print, as many of those accused of committing a felony by not signing the oath had not assisted in marking the elector's ballot. They may have assisted in filling out the oath of the elector and are assisted in addressing the envelope properly. But in most cases, signing the oath of a person assisting elector is not required. However, if an investigator were to ask an elderly elector or if anyone helped them fill out their ballot, of course they'll say yes, because in their mind they did have help with their ballot. The help was in filling out the oath and address correctly, and maybe applying postage for it. When the private investigator specified to witnesses using exhibits to demonstrate what is considered assistance with their ballots, they quickly clarified their answers, and not one of the witnesses interviewed thus far has corroborated any of the accusations of wrongdoing. We also had a new and at that time inexperienced registrar who had a lot to learn rather quickly. She was in constant communication with the Secretary of State's office staff as she navigated her first election, nervously trying to do everything just right. I'm sure she's probably made a few mistakes, but after this horrible experience, she will probably seek further employment. There is not one single element of this case that rises to the level of election fraud. There's not one single element that can support any claim of an elector not freely voting for the candidate of their choice. There's not one single element to support any claim of an eligible voter not being allowed to cast their vote. There's not one single element to support political corruption in our county. I would bet that if the state investigators scrutinized any county election in this state as closely and as for long as they have scrutinized ours, they would find a similar number of these mistakes and probably more. People are not perfect, and temporary employees who may work one election day every few years are bound to err. But as long as they err on the side of not denying a single eligible voter to cast their ballot, we have accomplished our goal as a free democracy. I feel it's very unfortunate that innocent, law-abiding Georgians can be dragged before this board and accused of committing felonies when a fair and competent investigation has not been completed. These matters will forever be a part of the public record, and these good and proud members of our community will forever be shamed and ridiculed for being undeservingly accused of criminal behavior by having their names attached to this report. I am hopeful the members of this board, Secretary Kemp, along with our legislators, will explore measures that might prevent other Georgians from suffering through such an embarrassing ordeal in the future. Best regards. Attached to my letter, you'll find several sworn affidavits that clarify and contradict information that you've been presented by Investigator Harvey and his report. Sworn affidavit can stand up in any court of law anywhere. To give you an analogy of what has happened here is we had a gentleman, we're known for our big deer and world record bass in my part of the state. This gentleman lured an investigation down here with tales of the big game we have. Well, once they came looking for that big game, they didn't find any because the guy was a fraudster. So before going back with an empty sack, they stopped off and bought a few packs of bologna. And that's what you have here is bologna. You can't make big game stew off bologna. I appreciate you all giving me the time to address you. It's upsetting to me. We've had so many negative issues surrounding our county historically. We've got new people in office. We're trying to change things because our economic plight is so bad. We don't have much industry. And we'll take the rap for what we do. And we'll punish those that have violated the law. But in this case, I'm telling you, there's nothing here. This was a fish expedition. When the complaints didn't pan out initially, for whatever reason, they decided to dig until they could find something. All you've got here is a few mistakes. And if you've ever been involved with filling out one of these absentee ballots, I'm sure you've made a mistake too. But I hope the board will consider the evidence that I presented. This case has not been adequately investigated. Witnesses have not been adequately interviewed. This case was thrown together. It was sloppily done. And innocent Georgians have been dragged through the mud by being attached to this report as a result of that. And I think that should never happen to any Georgian or anyone in this nation as part of that case. I appreciate your time, and any questions you may have of me, I'm glad to try to answer.
Any questions for the sheriff? No questions. Thank you, Sheriff. Anyone else wishing to speak? Yes, ma'am.
Good morning. My name is Linda Floyd. My address, 180 Spalding Drive, Murry, Georgia. I also received a letter. I didn't understand it, but they said that I assist Mr. Albert McCray and Mrs. May Mack. During that year, for as I can remember, if I assist anyone with their ballot, I will sign my name. I can't remember back in 2012. I just wanted to come and say, if I assist someone, I did sign my name. Thank you.
Okay, any questions for Ms. Floyd? All right, thank you for being here. Anyone else? All right, Mr. Harvey.
What hurts me, my county commissioners, Mr. S.O. Jones, Mr. Joe Wingate, and Mr. Howard Lawson, find nothing wrong with this. They find nothing wrong with this. How much can one community endure to have the right to have our votes cast and counted for who we want to represent us?
Anybody else wants to bring up anything else?
Anyone else? All right, Mr. Harvey.
Yes, sir. Mr. Secretary, could I respond to the sheriff's comments?
Yeah, I'm gonna let you do that. I got a question for you.
Yes, sir.
We had one, I'm trying to find my notes here. We had one person that said that they weren't noticed.
Yes, sir.
Do we have record of sending the notice?
We do. We've got, we scan all the notices that we send out before we do. I don't have all those copies with me, but we can certainly correct, or we can certainly verify that a letter was sent. You know, whether it's a good address or somebody has changed or it gets lost in the mail, but we can verify every respondent has sent a notice.
Yeah, I just want to make sure that it's clear that we did notice.
Yes, sir.
The individuals, so they could be here this morning to give us their side of the story. So,
yes, sir.
Yes.
If I may respond to Sheriff Steverson, I think I understand Sheriff Steverson's passion. However, I think his argument proves our point and discredits his own point. His basis seems to be that these are all good people and that the complainant is a nut, I guess, to paraphrase what he said. And we shouldn't have considered the allegations of a nut, and we should have known better, and we should have somehow made some sort of subjective analysis that, well, this person is making a complaint, and we should have known that he was crazy and not done anything about it. Instead, what we did is we took the complaints from this person, and we don't know anybody in Telfair County, whether they're, you know, unhinged or they have an agenda. Mr. Steverson made a complaint also that we investigated. We investigated the initial allegation about absentee ballots. How you investigate absentee ballot fraud is if there are specific people that are alleged to have had their ballot taken, you go talk to as many of those people as you can. If those names don't come up, you've got two choices. You can either say, sorry, nothing we can do here, or you take the extra, additional, and very time-consuming step of getting copies of all the absentee ballot applications, copies of the absentee ballot envelopes, going through them individually, identifying voters who have some type of discrepancy, randomly interviewing voters. Now, he indicated that we sort of randomly selected the people to interview. We did not. We randomly selected absentee voters, and we interviewed them, in many cases on tape, with an standard interview form, with experienced law enforcement investigators, and I would certainly dispute the allegation that Investigator Jones is anything but a top-notch investigator. She is one of our best investigators, and I would stand behind her 100%. But we interviewed these individuals. From these individual interviews of the voters is where we got the names of people that had supposedly assisted them. And contrary to Sheriff Steverson's understanding, filling out an absentee ballot envelope, oath of elector, is assisting under the law. So if somebody fills out an absentee ballot envelope, they are assisting the voter. He indicated that was not a violation of the code. I put to the board that it is, and that the board has always upheld that it is. The fact that the names of the people assisting came back to the investigators, and we went and made contact with as many of those people as we can, and again, over 45 interviews, letters sent to people. Yes, there were some people that we were not able to contact, and people that didn't respond, and opportunities that might have been missed indicate. But anybody, by any objective standard, looking at what we did, can say that we did exactly the opposite of what Sheriff Steverson suggested, that we went out to tar and feather somebody or to brand somebody's name. We followed the evidence regardless of who was involved. As a matter of fact, it was, I think, 2 days ago that when Sheriff Steverson contacted our office, I didn't even realize that one of the respondents was Sheriff Steverson's mother. There's no specific indication that that's the case. And I called the investigator and said, hey, in going over this case and getting ready, I see there's some connection, there's some mention. Is that person a respondent? And the investigator said, yes, it's this person. So there was no attempt to brand anybody. There was no attempt to go after anybody. We simply followed the voters who related their experiences with absentee ballots and led us back to the individuals that assisted them. So the fact that we followed the facts, and again, to say that we have somehow branded these people as felons, before this meeting today, the board will hear 25 to 30, 40 cases of individuals who are accused of doing the exact same thing that these individuals are doing. No specific recommendation has been made, nor will be made, that any of these people are handled any differently than any other people in the same circumstance. And I think the board would recognize that that's the case. If somebody illegally possesses an absentee ballot, the board has had a very long-standing practice of generally binding those people to the AG's office. The board can certainly vary from that if they want. I don't need to tell the board what they can do. But I understand his passion, and I understand that it's unfortunate that people that presumably have good intentions, and I have no reason to believe that any of these individuals who spoke had the intention of doing anything wrong, but the fact is, in some cases, they didn't sign as assisting. When they may think they did, we've got copies where they did not sign as assisting. I'm completely confident in submitting this to the board, and the board taking action on it, and if the board decides to send it to the AG's office will have sufficient evidence to take appropriate action for these violations. And again, just lastly to say, this shows there is no consideration of who the respondents are. We follow allegations and we follow violations, and when we find a violation, we make a citation. We've cited state senators, we've cited state representatives, we've cited candidates, we've cited family members.
Any questions for Mr. Harvey?
I have one. Mr. Harvey, look at the oath of the person assisting elector.
Yes, sir.
Carefully. It says that I've assisted the elector in marking such elector's absentee ballot as such elector personally communicated such elector's preference to me. It doesn't say anything about filling out envelopes or putting addresses on envelopes. This is talking about assisting the elector in choosing the candidate, just like the sheriff is said. Now, you know, if the oath should say something else, then it needs to be amended on the form. But this just says that you're helping mark the ballot. And we've heard, and I don't know that your investigator went that far in her investigation to determine whether the assistance was marking the ballot or just filling out an envelope or putting a return address on it or something like that. And I think it makes all the difference in the world.
Well, sir, respectfully, under 21-2-2 definitions, ballot, and I'm reading from the code, ballot means official ballot or paper ballot and shall include the instrument, whether paper, mechanical, or electronic, by which the elector casts his or her vote.
Right, but you're not reading what the oath says. The oath says, it doesn't say anything about saying that you have to, this oath doesn't say that I help fill out some other part of the ballot.
Yes, sir.
It says making the choice of the candidate the elector chooses. Now,
Yes.
if you didn't do that, you know, why would you sign this affidavit? Because it doesn't say I helped in any way with the ballot.
Well, it says ballot, and under the definition of ballot, the envelope counts as a ballot.
Yeah, but you gotta look at what the oath says, not what the statute says.
Okay. I understand, sir. And if the board, you know, wants to, you know, direct us to follow that, this is the standard that we've used for years, and we can certainly reconsider. I can talk with Mr. Willard if that's something we need to reconsider. I think if you look at the memorandum of interviews that we did, they do indicate in pretty great detail what the person did. the person, and you don't have that, but I'm talking in these files, when we do interviews, we do a question and answer form, and then it's summarized by the investigator. In some cases, it's audio recorded, and the investigators do go into specific detail about what was done. And in many cases, it was just that. It was that the assister marked the ballot envelope. And if the board doesn't believe that that's a violation, we can certainly adopt that. But it's been the standard practice that is considered assisting with an absentee ballot.
Regardless of what the standard practice is, looks like to me we need to go with the language of the oath rather than some standard practice. Particularly when some of these affidavits says, my daughter-in-law only filled out the mailing envelope in order to mail my absentee ballot. Doesn't say the daughter-in-law helped her select her candidate.
That's right. And in some cases,
says that I helped select a candidate.
And in some cases, I understand individuals have told us that they gave the ballot to one of these individuals, and now I'm hearing that the person has recanted and now is changing their story, which is something that would have to be determined at trial or determine witness credibility. I've not seen those affidavits, so I don't know what they say, but I had a call when Sheriff Stevenson said that Ms. Carnes called me. She called me, I think, Tuesday this week. She was interviewed in 2013, so she was interviewed. She may not have remembered being interviewed, but we've got a documented interview with her at the time. Like I said, we've got 3 accordion folders full of interviews and evidence and documents that have gone through to come up with these. And again, that's been one of our applications of assisting with absentee ballots, and if that's incorrect or improper, we'll make changes immediately. But and I would argue, I guess, or I would submit that Mr. Willard could determine whether or not, if the board wanted to send it over, whether or not that's something that he could proceed on. But the allegation that this was some kind of sloppy, haphazard witch hunt investigation is completely belied by the facts.
I'm not saying that.
I understand, sir.
All I'm saying is look at oath, look at what the oath says to determine whether or not there's a violation of the law.
I understand.
That's all I'm saying.
Yes, sir.
All right. Any other questions for Mr. Harper? Ms. Jones, I'd like to ask you a couple of questions, if you don't mind. Just give us your name, address for the record.
Pam Jones, Investigator for the Secretary of State's Office, 637 Coliseum Drive, Macon, Georgia, 31210.
I had a few questions I wanted to ask you. How long has you been an investigator for the Secretary of State's Office?
6 years.
6 years. Do you believe that when you were doing this investigation, you were one-sided in it?
No.
Do you believe that you randomly selected the individuals that you talked to or interviewed in this process?
Yes.
And why would you do that?
To get an adequate sampling of the alleged violation, so that not to take too many people from one district. I went through the stack of applications or ballots, and like every 5th person pulled the application to review, and until I could get the number that I needed.
So when I say randomly selected, it wasn't like you just went down there and picked the people that you thought you should talk
No.
to. You had a process on how you would do the investigation.
Yes,
That
we
would give-
decided that 20% would be an adequate review. In discussing with our supervisor and Mr. Harper, we decided 20% would be sufficient number.
Do you feel like anybody has been dragged through the mud on this investigation, or have you handled this like you've handled the other investigations that you've done in the 6 years that you've been working for?
It's been handled exactly the same way. There's been numerous investigations regarding the same allegations, and we always handle them the same way.
Could you tell us about how you went through the contacting process of the individuals that claimed that they were never contacted, that they were never talked to, that they called you back, left messages, and then you didn't call them back?
Primarily, the initial contact is done in person if you can. There's the distance issue with us was a problem because we're almost 2 hours away. And time constraints, but I would initially try to make contact in person. If that wasn't possible, then I would research and try to get phone numbers. I contacted by phone and left messages. Some cases you can't leave a message, some cases the phone's been disconnected. And then last resort is to send a letter. And typically it's done by certified letter. We do have issues sometimes in getting our green cards back. Lost some mail, we have a huge mail run here, so that's the case sometimes. So.
Okay. Anybody else have any questions for Ms. Johnson?
When you interviewed these people, did you ask them exactly how they assisted the person with absentee ballot?
Yes, sir.
How many of them, or do you know reflect which ones said that they assisted in selecting the candidate?
I would have to review the MOIs because that's usually done as a collective number because we've always treated assistance, including the ballot as well as the template because it's considered one document.
What's confusing here is it says your findings in your report just say that they assisted, it doesn't say how. You see where we are.
And that's something that can be reviewed. We can review the MOIs to tell the difference, but because that is a specific question that's asked, but typically that's considered a violation because it's considered one document.
And the MOIs, not to interrupt, but the MOIs do generally indicate if the person assisted, they helped me choose the candidate. In some cases, I believe Ms. Studdard was blind, and she said that, I think it was Ms. Dollar, whoever assisted her, she told her who to assist. And so it indicates in the MOI that Ms. Dollar marked the ballot for me and then showed me what was on there. So if you look at each individual interview, it generally indicates to what extent they assisted.
Thank you. All right, anyone else wishing to speak that hasn't spoken? All right. Sheriff, do you have something you want to add?
Yeah, I'll just add that in the report that you all have, it says basically that the complainant's allegations could not be corroborated. At that point, I want to understand why they went on such a fishing expedition when they brought us all here today with a bunch of errors on the voting process. And also, if one does not understand the law or the rules for the absentee ballots themselves, I don't understand how they could be expected to investigate it and bring these good people before this board. As I'll stand by that this investigation was done sloppily. This investigator has no criminal investigations experience besides her experience since being hired with this board. And there's a lot more that could have been done. And you all must agree with me that the verbiage on the absentee ballot as far as the oath is very confusing. And you'll have hearings from now until the end of time to cover everybody that makes mistakes on those. These people try to do the right thing. They're not criminals. They don't have criminal records. They don't have criminal histories. And it's unfortunate that they're here today.
Thank you, Sheriff. I would just say that these technical errors on voting and forms and procedures, we have laws, rules, and training for a reason. And we've had cases before where we've had people that didn't do those things properly, which calls into question those ballots and those votes. And I know the sheriff and I would both agree as elected officials that if the election doesn't go the right way, we can have elections contested over such matters. So I would disagree with allowing small details to slide in the elections process because it can create some big problems down the road. Just hold on one second, ma'am.
Mr. Chairman, I may not should interject this because I don't know anything about the absentee ballot situation. My client's not involved in that. But I just feel like I need to get this out there when Ms. Jones stands up here and says that she contacted everyone or attempted to. The former election superintendent, who was the election superintendent at the time, was not contacted, and she's been living at the same address in Helena and has the same phone number for 30 years. Just want to get that out.
Yes, ma'am.
I'm viewing
Ms. Dahl, you got to come on back up here to the microphone for me.
I'm viewing dollars, and I want to find out if it's proper for the investigator to harass and intimidate relatives that are deceased or by the absentee ballot.
Well, ma'am, I think if you have a complaint about somebody harassing or anything
No,
else.
investigate, yeah, what I need to write to the
Yes, ma'am.
Secretary of State.
Yes.
Okay, thanks.
All right, anyone else? Okay. Ms. Harvey, do you have anything else you want to add?
No, sir. I think
Let me ask you this, on the more serious potential allegations, do you feel like it would be beneficial for us to table those parts of the case where you could pull out and look at, you know, the investigative documents and give the board some more detail in the future on those? Or?
Well, I don't know that that would necessarily be helpful. My thought is with the allegations that have been cited are pretty clear, and if it's determined that those are not good citations, then I think the easiest way to go forward would be for Mr. Willard to evaluate each of them and then, you know, close cases or dismiss respondents as necessary. You know, Sheriff Stevenson said that, you know, there is no real fraud going on down there, and you know, frankly, we didn't find evidence of real fraud down there, and I don't dispute that with him as far as our evidence goes. But you know, as you said, you know, little things matter in elections, and details are important, and I don't know that there's going to be any more detail that we could gather. I think maybe a better use would be for to us, maybe in consultation with Mr. Willard, if you bind it over, is to, you know, determine, you know, how far this assistance gets pressed, or clarify that, so that, you know, we can look at each case, because in some cases people did say that this person marked their ballot for them. In other cases, as Judge Simpson said, they admitted addressing the envelope. And I think if we use this case as a marker to maybe clarify those standards, that may be more beneficial than us just going back, because essentially what we would do would be go back to pull out the MOIs and say specifically, okay, this person did this, and all that information is already in here. So I don't think there's anything else we can do.
Well, I guess my question was if you thought the board would benefit from seeing any of that in light of everything that's going on.
Certainly, I'll be happy to do anything the board wants. I think as by way of resolving it, again, if Mr. Willard were to go through and say, hey, this person, based on this level of assistance, does not constitute a violation, that will be sort of a marker, so the board will see, you know, because of course the board will have to agree with that when Mr. Willard brings it back to say, hey, we're dismissing this case against Joe Smith because all they did was address the envelope, and that's not a violation. And I think that'll distill this back out. So we've got, you know, approximately 10 respondents on various charges of assisting and possessing. And I think when he brings it back to you at some point in the future, you can say, okay, we're recommending you dismiss these 3 people because the only thing they did was address the envelope.
Do you have any response to Judge Johnson not being contacted?
I don't, except that I know we contacted we contacted 4 out of the 5 poll workers at the precinct where there was an allegation. I don't have a response to that, and that would not be something that would normally be an omission that we would make. The only other thing I would say, I guess, is that the absentee ballot issue is handled by the Registrar, so I think that was more of our focus. But in hindsight, yeah, talking to the election superintendent regarding the voter certificates would have been would always be advisable.
All right, anybody else have any questions?
Well, Mr. Chairman, I had a position and then possibly some questions. I tend to agree with Mr. Harvey that there's enough evidence here that's been raised, even though there's affidavits that have been presented in opposition to it. It seems to me that the most efficient way to deal with this case would be to bind a lot of it over and have Mr. Willard look at these affidavits and the other information that the investigators have brought forward. And there are a couple of things that I would like Mr. Willard, just speaking for myself, not the board, to a couple of issues to look at. One is the sufficiency in the issue of the oath on the envelope, and whether, as Judge Simpson has raised, whether that's a violation. And that's the main thing. And then also the interrelationship, which I'm having a little problem with, between assisting an elector and then possessing the ballot. It seems that there are some of these people who've been charged, or who may have properly assisted an elector, but then were charged with improperly possessing the ballot. And I'm having a little trouble understanding that.
In every case where somebody is cited for possessing a ballot, the voter has told us that person who assisted them took the ballot with them. So that nobody is cited for possessing, for merely touching the ballot while assisting. So anybody who's cited as possessing is alleged to have taken the ballot in their possession away from the voter.
Well, I would like Mr. Willard to look at the issue of how that really works as a practical matter, and is that really what the statute intends as a violation for somebody who's allowed to assist, but then can't walk the ballot to the person that they're assisting's mailbox, which seems to be
I understand.
an issue. So that's generally the position I would take. It may be that there are a couple of these people and issues, as Mr. Harvey has suggested, that could be dismissed at this point, and I'd be happy to look at those. But generally speaking, I'd vote to bind it over, and I was also particularly disturbed with what appeared to me a large number of voter certificates that went out.
Anybody else?
Completed.
I'd just like to say, I think the absentee ballot area is the one area that we have to be very, very careful about looking at. We need to look at it under a microscope, because that's where fraud is the easiest to perform and it's the easiest to affect the outcome of elections. That is an area where voters are most vulnerable. That's an area where it's easier to commit a voter fraud than anywhere else. And I think we need to be especially careful in that regard. But I do think that we have a problem in this case about not knowing, based on what we've been provided today and what the sheriff has provided us, whether or not these people that assisted and didn't sign an oath are really in violation of the law or not. And without knowing specifically, in my mind, whether somebody helped an elector check a candidate or just addressed an envelope, it makes a world of difference. And secondly, I don't see how someone that is blind and homebound, the person assisting that person that takes the ballot with them to mail it, how's that person going to get the ballot back? How's the disabled person going to get the ballot back if you don't have that transmitted by the person assisting? And I wonder about that. And also, what bothers me is to make sure that every citizen gets the opportunity to vote, particularly those that are disabled. can't do it in a normal manner. And we need to be very open to making sure that the assistance they get and that they get the same protections that all the other voters get in casting their ballots. But under these circumstances, with regard to these assisting charges and things like that, I don't think I could vote to bind this case over based on this record. And the second thing is that with regard to the superintendent and the board of registrars, Roy Sawyer has done a good job in her response and shows that the county has taken substantial remedial action already. And I wonder if this case, if that portion of the case is found over, I would encourage an attempt to come to a consensual resolution of that based on the remediation that the county has already taken, which I think serves very good.
Mr. Willard, would you mind, or if you can, explaining, who can legally assist and who can legally handle the absentee ballot? Is that something you can?
Well, I can point you to 21-2-385, Mr. Chairman. A physically disabled or illiterate voter may receive assistance in preparing the ballot from any one of the following: an elector who lives in the same county, an attendant caregiver, or a person providing attendant care, a relative, defined as a mother, father, grandparent, aunt, uncle, brother, sister, spouse, son, daughter, niece, nephew, grandchild, son-in-law, daughter-in-law, mother-in-law, father-in-law, brother-in-law, or sister-in-law of the disabled or illiterate elector. That's who can provide them with assistance in the ballot. I will confess, Mr. Chairman, this is the first time I've ever seen a case in my representation of the board where we've dealt with, they're not telling them who to pick, or they're not helping them write who to pick. There's some allegations that they just filled out, return address. And I was talking to Mr. Harvey during the presentation, and while Simpson raised the issue of the oath, that is corroborated by how the General Assembly has defined 385B, where they distinguish a person assisting them in completing the ballot, and then they mark that assistance on the envelope. So the General Assembly has bifurcated the terms and refers to a ballot and then refers to the envelope that you execute the oath on. So I think the General Assembly has, whether you argue it's through omission or what, has said it is not assisting an elector if you're making a mark on the envelope. You are not assisting them with the ballot. I think that's clear on both the language of the oath as well as in 385B. Now, I think you also asked, and Mr. Worley had alluded to it earlier, who can actually possess the ballot. And, Mr. Chairman, I've had some colloquial conversations with representatives from your office. We're going to be coming back to the board with a bundle, presumably at the next meeting, where we're going to be taking a position on that. But it's going to be premised on the use of the terms the General Assembly has elected to use. And they talk about that the elector must mail, and then they employ the disjunctive or, and then they employ the term personally delivered. The adverb personally does not modify or relate to mail. And I think that's critical when you look at the rules of statutory construction. And so I think the General Assembly has actually taken care of the issue of how a disabled voter or an illiterate voter actually as well gets their ballot back to election officials. And that is, they have not restricted mail to include the term personally. But like I said, we do not have those cases from our office. With a recommendation back to you, but I think that's going to be where our advice is going.
Well, I mean, I guess my question to that would be is in the past, we've had people that have maybe not filled the ballot out, but they have taken bundles of, 50 absentee ballots and mailed them, and we've cited them and, come to a consent order with them if they violated the law being in possession.
I understand, Mr. Chairman. That's why I'm not saying that as a matter of law, I'm telling you today, you can't bind these cases over. I'm just saying that this is probably going to be a full and vigorous conversation with the board at a point in the future. But the General Assembly has employed specific terms. And I have talked to Ms. Brumbaugh when she was with our office and then when she left our office and was working on legislation about this issue. She's been cognizant of this fact. And the General Assembly is considered to have known what it meant when it used the adverb personally to modify only one of those words.
Well, I think, at the end of the day, we've got the law and the state election board rules that we, have to have them followed and we have to enforce. And one thing I think that I've seen, I know in the 5+ years that I've been chairing this board, is that we've been very consistent on how we handle these type of things. And I think that's good for us as a board. I think it's good for the elections officials, and I think it's good for the public as far as us having secure, accessible, and fair elections. And when we start kind of picking and choosing how we're going to do that, I think can get us into some trouble down the road. All right, anybody else got anything?
I did want to say one thing, just to be clear on the record, is I don't fault the investigator in this case or any of the investigators who work for the Secretary of State. They do very good work, but they're only following the rules as they understand them that we've been operating on up to this point. And so I just wanted to make that clear. I did have some questions about some of these specific charges that maybe we could deal with today. And I apologize, but Mr. Hartley mentioned that there were a couple of items that he thought might be dismissed in his initial presentation.
There was, I recommended that for Inez Carnes and Martha Williams, they received letters of instruction for assisting without signing. They assisted their husbands, and I think. Sir?
That's not correct.
Our evidence showed that they assisted their.
96-year-old
All
father.
right, Sheriff, we're going to stay orderly here. We've given everybody an opportunity to speak, so.
Who was her father, sir?
So anyway, that's the recommendation as regards them with the assistance letter of instruction.
And what was the reasoning again for the letter?
Well, again, because it was a family member. It was, I think in the past the board has viewed a distinction between assistance, among family members that might technically be wrong when you don't sign, but it's different than a candidate or a member of a campaign coming and assisting somebody. I think.
So you're saying that this is more of a technical violation, and in the past we have written letters to make the technical violators aware of what the law is, and information purposes. There's no other penalty along with that, correct?
Correct. Just a letter restating the requirements for assisting a family member.
All right. You want to keep going with that a little bit?
The other question that I had related to Fred Heyman.
Yes, sir.
And this idea that there was a charge against Linda Cartwright that she had permitted Mr. Heyman to vote. And the testimony was that what was presented was that another poll worker and not Ms. Cartwright handled that. How do we generally handle these cases? Is it
Usually,
The manager?
usually the poll manager is the person, because so often in the course of a day, different people do different jobs, and it's impossible to determine who gave him his card or checked his ID. So the poll manager is generally cited for an event like that.
That would, we wouldn't. What was the recommendation on Mr. Haynes the third?
That he be bound over also for voting while unregistered.
So he was not registered.
Correct.
And he voted because they used the other name.
Well, he went in to vote, and he put his name on there, and his name happened to be the same as his grandfather, who was registered to vote. So they pulled up Fred Heyman and said, okay, you appear to be at this address, so they gave him a card, and he voted.
So he voted not being a registered voter.
Correct.
Well, and I guess the sheriff indicated that it was either he did or it's possible that he had received his grandfather's or his father's new voter registration card and voted on that basis.
Yes, sir.
Mr. Chair, may I clarify something about Mr. Haynes?
Yeah.
I was told that Mr. Haynes, grandfather and father, when he became deceased, the board or the elections commission or whatever took the wrong name off the registration form. I'm under the impression he was registered and he was mistakenly purged, so when he went to vote, he was allowed to vote.
And I'm sorry, Tony Sargent on behalf of the Board of Elections and Registration. Again, there were 3 Fred Haynes registered at the same household. Fred Haynes III did not pass away until August of 2012, which was after the July primary. There were 3 Fred Haynes at that one address, and that's where the confusion came in. There was the senior, who was however many years old, 90-something years old. There was junior, who may have been deceased, and then there was the third, which is the grandson, which is where the issue arises.
So the grandson was registered.
Yes, sir.
Then was taken off the rolls because the registrar thought that he had deceased, mistaking him for either the senior or junior.
Junior probably, his father. But then with the card, I guess, and again, I wasn't there at the time. I only know what I was advised by my client, which unfortunately they weren't able to be here because of doctor's appointments, of spouses, family members. But the confusion came about with just the name Fred Haynes. You know, it didn't have junior, senior, the third. It was just Fred Haynes. And they didn't check the birthday, unfortunately.
According to the
Also
report,
got the issue with the registrar.
well, according to the report, he was not registered. Fred Hammonds III was not registered, and he wasn't registered at the time when he was interviewed in September of 2013. And at that time, he was advised by the investigator that he still wasn't registered to vote.
But was he registered before and was taken off by mistake? Is that what happened? I'm trying to figure out what happened.
We can, during a break, we could check to see if he was ever registered before, but again, based on the report, he was never registered.
Well, I can follow up with my client, just to make sure and provide the information with you all.
All right, did you get your question answered about the poll man? Okay. All right, yeah.
Thank you.
Thank you. All right, Mr. Harlan.
Well, actually, I did have one. When we get to the point of discussing who to bind over, what to bind over, Ms. Carnes and Ms. Williams, would be my preference not to send them a letter of instruction until we've figured out exactly what the board's position is going to be if we would advise the Attorney General on these kinds of issues. Because I don't want to send them a letter, even though it's only a letter of instruction, don't want to send them a letter of instruction if it's turned out that they really didn't violate the law.
The affidavit you have said they only filled out the envelope. Ms. Marks only filled out the envelope. She didn't help with selecting the candidate. So I would agree. I would not be in favor of backing that over or issuing a letter. I would be in favor of dismissing those two.
And to, Mr. Chairman, to avoid any confusion about what I said, and I realize that sometimes I'm a little obtuse in what I say, in terms of signing the oath and assisting on the ballot, there's no equivocation on our part. If you do not actually assist them on the ballot, if all you do is assist them in filling out the envelope, that is not something that they are required to execute the oath for.
Kelly, you would turn dismiss. Any of the others, if that's the case.
You want to go back through the recommendations?
Well, based on that, it might make more sense to, and it may be something that we can do in the background of this meeting and bring this back up at the end of the meeting and get those answers to who exactly did what with this assistance. And so we may be able to resolve it later today. If you want to table it temporarily, we can come back with each of these individuals and say, okay, this person assisted with the actual ballot and this person just signed the envelope, and that will answer your questions. And while I can't do that right this second, we can certainly get that done in the next hour or so and bring it back later this afternoon and resolve it that way.
All right, well, let's do that. Let's take a lunch break. It's 12:35. We'll try to come back at, I guess, 1:25. We'll take a lunch break till 1:25.